to remember your question. Sometimes it's difficult to remember your questions towards the end of the session, so as you think of them, you can send them in through the chat box, and then I will have access to them. At the end of the session, we're going to make sure that we have time for answering questions. Additionally, the follow-up to today's webinar is going to be an article that addresses the same issues and will be available through the National Domestic Violence Fatality Review Initiative website. And your questions will help to inform me about what points need to be additionally clarified or addressed, what makes sense to the folks who are using this information. Because that's really the point of today, is to take an educational look at the law around confidential information, but think about it in the practical context of conducting a fatality review. So I am going to be a little bit lawyerly and teach you what some of the rules are, but then we're also going to take a step back and say, okay, in real life, when we're really doing this work, what do we do about this? How do we get what we need, and how do we balance the very important goals of confidentiality with doing effective, impactful fatality reviews? So the specific goals for today are to come away with a strong understanding of the distinction between privacy, confidentiality, and privilege. These concepts are siblings, maybe even cousins, definitely not the same thing. Then we want to identify what are potential legal barriers to obtaining confidential and privileged information. We want to consider what the practical issues are around seeking, possessing, and protecting sensitive information. Sometimes we have a tendency to focus on, can I get it? But the true survivor-centered informed approach to confidential information is to also pay attention to what you're going to do with it if you do get it. And then finally, we want to ensure that the overarching goals of fatality review and practices around use of sensitive information are in alignment with each other. So I want to start with the goals of fatality review, that the fundamental reason why we engage in this intensive analysis of what happened to someone in the past is because the goal is to prevent future deaths. Right? We want fewer people to suffer harm from domestic violence, and we want fewer people to suffer the ultimate harm of being murdered by their partners as a result of domestic violence. We want increased safety for victims of domestic violence and as they are escaping, coping, living their lives, and living their lives after abuse. And part of fatality review is a belief that safety is increased when people have an increased access to effective systems, right? Both things are important. Both that access is increased, but also that the thing you get access to is in fact an effective system that is working well. And then finally, one of the goals of fatality review is accountability for perpetrators. How do we think about implementing our government and social service systems in a way that provides for more accountability, because accountability in turn reduces death and also increases safety. So here's my biggest message for you today, which is that privacy and safety are linked. Privacy and safety are linked to each other. They go hand in hand. So starting with thinking about privacy, right? We have this idea that privilege, confidentiality, privacy, all these things basically mean somebody saying, shh, don't tell. I want you to keep this a secret. We're going to take a little bit more of a granular look at those concepts to think about what do we really, really mean by them, because these become very important with how they play out in our practices. So the first concept is privacy. Privacy is something that comes up constantly these days because of our life in the electronic world, in the share everything with everybody world, right? We're all instantaneously connected worldwide, and we have the ability to do something as momentous as to define major life changes online in connection with thousands of people at the same time, or to do something as silly as when I put up my silly 1970s Christmas special figurines on my fireplace, I can take a picture and post it on Facebook, right? It runs the gamut of sort of just simple, silly, fun communication, but also really serious and sensitive communication. So privacy is becoming a concept that we all have to think about and define how we approach it and possibly redefine how we approach it because of the changes in technology. But it ultimately comes down to something very, very simple, which is I decide who knows my information. That is all privacy means. I decide who knows my information. So when you get a privacy notice from your bank or a privacy notice from a website, what they are saying to you is not, we are going to keep your information secret. That's not what their privacy notice means. Their privacy notice means we are going to tell you how and when we will protect your information, and how and when we will share your information, and how and we will exploit your information. And I don't necessarily mean exploit in a bad way. I just mean using it for their own purposes. That's what their privacy notice means. Because once you get that notice, you get to make the privacy choice of whether you are okay with their terms. And if you are okay with their terms, then you share information with them. And if you are not okay with their terms, then you are allowed to stop sharing information and to move on to a different bank, a different website, whatever that may be. So privacy is the right to make choices. Confidentiality is a promise to protect information. It is a promise that typically comes from a professional who says, I promise you that if you give me this information, I will protect it. I will do everything in my power to protect it from other people and to only use it for the purposes that you gave it to me for. Now, one of the important elements of confidentiality is that when you make that promise, there might be places where you as a professional are legally unable to protect information. For example, if you are a mandatory child abuse reporter, you can still have confidentiality, and you can still say, I promise to protect your information. And it's important that you know that if you tell me that a child is currently being hurt, I am going to be required to report that. That is an exception to my promise to protect your information. But I'm telling you in the beginning because you get to make a privacy choice whether to share that information with me. So this is how they're linked, right? Confidentiality is I'm promising to protect your information and I'm giving you choice. And part of giving you choice is telling you where I might have to share it against your will, against my will. The third concept is privilege. Privilege specifically means law that says that you can't be forced to share information. So law that says that if a judge hauls you down to court and says, I want you, lawyer, to tell me what your client said to you, privilege law says, I'm not going to answer that question. As the lawyer, I'm not going to answer that question. My client is allowed to prevent me from answering that question, and you can't punish us for not answering that question. That's what privilege means. So it's very specific in a lot of ways to the courtroom and to what can a court of law force you to do. The way in which confidentiality and privilege are linked to each other is that if somebody has made you a confidentiality promise, or has a legal confidentiality duty, they have told you, we won't release your information to anybody. Privilege means that when your professional takes that position, I won't release this information because I promised not to, that a court of law can't force their hand, and a court of law can't punish you for doing that. I like to take a moment and step back from the privacy, confidentiality, and privilege and think about who exercises them. So I've touched on this already, but I think it's worth it to articulate it clearly. Individuals exercise privacy, and they need privacy to exercise control over life situations. Professionals promise confidentiality for the purpose of fostering client relationships, right? We promise people that we'll protect their information so that they will share it with us, so that we can do things for them. Governments bestow privilege because they're protecting social values. So governments give a privilege to lawyers, to domestic violence advocates, to psychiatrists and psychotherapists and doctors and religious officials. Governments give privilege because we think it contributes something valuable to our society to have that information be protected, be safe, stay secret. And there are costs to privilege, right? There are things that the government is giving up, like the right to hear the information. But that's okay, because the value to society of protecting it is greater. It's all about trade-offs. So why do people need privacy? Why does it matter so much that people have the ability to exercise choice over who knows what? and how is it that privacy and safety are linked to each other. People worry about their reputation in the community. We know, and you only have to live in this society and be exposed to our culture for about 10 minutes to know that being the victim of domestic violence or sexual violence or any other kind of gender-based violent crime carries a stigma for the victim. People worry about their reputation in the community, and so they worry about who knows what and how their story does or does not get out because of the unintended consequences and the impact that it might have on them that they have no control over. And the truth is, when we're looking at a domestic violence situation, ironically, control over who knows what might be the only autonomy that a victim has left. Literally, the decision about who knows that somebody's partner is being abusive might be the only real choice that's left in their lives because they are being hyper-controlled. It's an odd thing, right? People exercise power and control in whatever space is available to them. And so somebody who is suffering very controlling, serious domestic violence may well find it very important to their own sense of well-being to exercise control over who knows that it's happening to them or not. And so unfortunately, if victims are worried about whether or not their control over who knows what will be impacted, and they worry about what their reputation might be, they will turn away from services if they think their stories might get disclosed. We actually unintentionally got an example of this about 25 years ago. The state of Pennsylvania had a confidentiality, a privilege statute for information shared between sexual assault advocates and sexual assault victims. There was a Supreme Court case that came down that said that the way the statute was written, it wasn't actually as protected as we thought it was, and that the information could be disclosed in a criminal case. Immediately what happened is that victims started calling sexual assault hotlines and counseling programs and saying, I'm not coming back, I don't want to work with you anymore, and I want you to give me every single copy of my records so that I can control and disclose them, and I don't want you to keep any. That had nothing to do with the services that the sexual assault providers were giving. It had to do with the perceived risk that information could get out. Now, the good news is that this was clearly a crisis, and the Pennsylvania legislature went back to the drawing board and fixed the law and made it one of the strongest and most protective statutes in the country. So folks who are on this call from Pennsylvania, don't get worried, you have a terrific law. But we had this brief moment where very publicly it looked like information wasn't safe, and we saw the way that victims reacted to it. So it was just a confirmation of what we already knew, that people care about who knows what about them. So if we're thinking about people worrying about their reputation and their choices in life, what does that mean to think about their privacy after death? Does it then, do people have a vested interest in controlling who knows what about them after they die? And the United States Supreme Court has actually looked at this question in the context of attorney-client privilege. And we'll get into specific protections for different kinds of information in a few minutes. But I think that the Supreme Court actually did a really nice job of laying out why it matters whether or not you protect information after people die. And this is the quote: "Knowing that communications will remain confidential even after death encourages the client to communicate fully and frankly. Clients may be concerned about reputation, civil liability, or possible harm to friends or family. Posthumous disclosure of such communications may be as feared as disclosure during the client's lifetime." And that quote comes from the Swidler and Berlin versus United States case, which, depending on the age of those of you on the phone, you will remember the Kenneth Starr era and the disputes going on between the Clinton White House and independent counsel Kenneth Starr, back and forth about getting access to information. This was part of that whole era, and Vince Foster, who was a deputy White House counsel, unfortunately committed suicide, and he had consulted an attorney 9 days earlier. The independent counsel's office was trying to get access to the attorney's notes about that communication and arguing vigorously that when we were looking at the question of criminal liability, that there should that we should get that information after the person has died because they don't have an interest anymore in protecting it. And the United States Supreme Court came down very firmly, not unanimously, but very firmly, that people care about whether their information gets disclosed after death. And so there are very good reasons to protect privileged and confidential information even after somebody has passed away. So these are the questions that run through people's minds. Will this ever get out to someone else? You know, people do care about their legacy, right? That's the term we use for reputation after somebody has died. What will my legacy be? Will the abuser find out she helped me? It's interesting, and those of you who have done direct services, you know how much survivors of domestic violence often find strength in worrying about and protecting other people. So one example I can think of is a terrific book called Saving Bernice by Jody Raphael. And in that book, Jody Raphael does a series of interviews with a survivor of domestic violence, severe violence. And one of the things she said is that there was a point where she was ready to leave her abuser, but he kept saying he was going to kill her caseworker at a workforce development project, who she had a very close relationship with. And so she was terrified that he would kill her caseworker. So she didn't leave him in order to protect the caseworker. Now this all comes out because the caseworker has a conversation with her and she says, I can't leave him because he's going to hurt you. And the caseworker says, I'm going to take care of me. I'm safe, I've got protections, and so we need to take care of you. How can I help you? But this issue of people not taking action or taking action because they're worried someone else will get hurt is very, very real. And even if it's not real, the belief that an abuser is omniscient, right, and has sort of more power and more control in the outside world than they really do, that feels very real for someone who's living in the situation. So that belief that information that you share about how someone else might have helped you might get out to the abuser even after your death and therefore cause harm is going to be a very real issue that could chill people from sharing information to get help. There's also the very real issue of families. Even after somebody has passed away, will his family go after my family? And I had to learn this when I was doing work with a lot of folks who were immigrants to the United States as a legal services provider, and they would say, my biggest concern is that my abuser's family will harm my family in our home country. What can I do about that? I can't file divorce in the United States because it will cause somebody to be physically hurt back home. Finally, will this hurt my kids? Even if somebody is concerned that they might be murdered, they may believe that their kids will live on beyond them. And will something in the records of what I've told you get out and do harm to my children? And that's not just the abuser going to harm the children. It could also be that having the children know or find out the details of what was said and what happened feels like it is a breach of loyalty to your kids to even sort of put out in the world negative things about their other parent. And then finally, will I be shamed in my community? Something people worry about enormously. So I can imagine for folks who are on the phone, you're thinking, yep, we get it. Like abusers are a problem. Abusers control information, they misuse information, they do harm to people, but we're the good guys. We are the people who are working on solving this problem, and so we're not the ones who need to have the information protected. And I'm with you. You are the good guys, right? We're all part of the systemic response to eliminating domestic violence. But for a survivor who's just trying to predict the future, the fatality review team are really more like the unknown guys. They don't know who you are. They have no idea if you're ever going to be looking at their situation in their case, right? Because by definition, you're looking at cases after people have passed away. You're just someone who they don't know. And if people knew what happened to me, what would they think of me? Often disclosures in by a domestic violence survivor, there's the first disclosure. Last night, my husband slapped the kids. And that's not okay, I want help. And then there's the second, third, and 10th, and 20th disclosure after you've developed a relationship and you've begun working together, where the survivor says, So I'm ready to tell you that he raped me on our wedding night, and it's been happening ever since. But I was never going to tell you that until we built a relationship and I got to know you. And I don't want that to go into any court pleadings. I don't want to make a police report. I don't ever want my kids to find out that their dad did that. And I would never have told you that if I didn't know you. For that survivor, you on the fatality review team are a person they don't know. And frankly, by definition, they're never going to have a chance to know if you're looking at their case after they've died. They may be so invested in you not having access to sensitive information that it could prevent them from sharing it during their lifetime to get help. So when we're thinking about how do we do fatality review and how do we make decisions about whether we should pursue access to sensitive information, I think the question that every fatality review team has to ask itself is, if survivor concerns about privacy are real to them, and that those concerns could chill their comfort with seeking help, will a disclosure to fatality review endanger safety and access to services? And that is a question for every team to ask and to look at in your community. Some of that is going to have to do with what do the laws look like in your community, what is the culture like in your community, what is the level of trust in your community, and we're going to go through looking at some of those questions as part of today's webinar. But I call this the could-should dynamic. There are really two questions that you're asking every time you're developing strategy. And the first question is, can we do something? Can we physically, legally do it? Are we able to? But the second question is, should we do it? Can we do it? Should we do it? Just because we can do something doesn't always mean we should do it. And what I'm asking of programs today is to always be engaging in that question. What can we do and what should we do? I'm not here to tell you what the answer to that question is, but I am here to say that if we are really being survivor-centered, trauma-informed, and trying to improve systems for future victims, we always want our teams to be asking that could-should question. Okay, so let's talk in a little bit more detail about confidentiality as a promise to protect. Excuse me if you just heard me taking a drink there. This is the downside to the webinar format, right, is that none of you have to travel. Some of you might even be wearing pajamas, but it means I can't see you and you can't see me. So I'm hoping that you're here and that you're engaged, and I would really love it if you send in some questions. Even though I won't get to them towards the later part of the session, it will help me. And if you have no questions because everything is crystal clear and it makes fabulous sense and it's enormously useful, hey, feel free to send that in too. Okay, so confidentiality is a promise to protect. You have given me information and I have put a chain and a padlock around it. It's protecting survivor choices. Remember we talked about privacy being choices about who knows what. Confidentiality is protecting survivors' choices. Please give me this information. I won't give it to anyone else. If there's some reason I have to give it to someone else, I'll tell you in advance, and it's your choice whether to give it to me or not. So sometimes when we talk about confidentiality and really any kind of sharing, sometimes people will say, well, the victim gave me the information and I promised to keep it confidential, and now I'm going to give it to someone else, to the fatality review team, and they're going to promise to keep it confidential. So that's okay, right? The problem with that is that who's making the choice there? The choice whether to share with the fatality review team is not being made by the survivor, it's being made by the advocate or the professional who possesses the information. So when we do that, we're not protecting survivor choices. Right? We've lost track of that because we said to the survivor, give me this information so that I can help you solve your problem. Now if we said to the survivor, give me this information so that I can help you solve your problem, and then also I'm going to share the information later if you die so that we can help the community solve a problem. That might be okay because then the survivor gets to make the choice. But I can already hear some of you out there groaning and thinking, oh, if we said that, you can't really say to somebody, I'm here to help you make things better, but if you die, I'm going to share your information with the fatality review team, right? If we feel nervous about how survivors would respond to that, then we should pay attention to that nervous feeling because it's telling us that there might be something inappropriate about it. I heard I was talking with a colleague of mine who's a bioethicist who said that sometimes she will talk to doctors, and doctors will say, I want to get informed consent to prescribe this medication to this patient, but I don't want to tell her that it's a psychotropic medication. Do I have to tell her that it's a psychotropic medication? And the bioethicist will say, well, why don't you want to tell her? And the doctor will say, well, because if I tell her, she won't want to take it. And the bioethicist says, if this is a piece of information that giving it to her would change her mind, then it's a material piece of information. You have to share it. So this is a sort of a similar thing, is that just because the advocate or the professional sharing the information believes that it's okay to share it with Fatality Review, or believes that Fatality Review will keep it private, it still counts as a disclosure. And if it wasn't the kind of disclosure that you told the survivor in advance that you were going to make before they gave the choice to give you the information, then you're not protecting their choices, and we have to examine whether that's okay or not. I want to emphasize that confidentiality might be a legal requirement, it might be an ethical duty, or it might be both. So confidentiality requirements appear in the National Association of Social Work Ethics. They appear in attorney rules of professional conduct. They appear in statutes, and we'll go over some examples in a minute. So there could be a couple of different places where it appears. I mean, frankly, I offer confidentiality all the time in my work, in the sense where I say, if you tell me this, I will not volunteer it to anybody. But also it's important for you to know that that's my ethical approach to this, but I'm not representing you as a lawyer right now, so I can't promise you that no one could ever force me to share it. I'm just telling you that I'll never volunteer the information. That's me offering confidentiality, but also telling people up front what the limits of it are. But when I'm representing a client, I have both an ethical duty to keep confidentiality under my rules of professional conduct and a legal requirement under legal privilege. And so the question of whether or not confidentiality explicitly extends after death in an ethical duty or a legal code really depends on your local statute. So there's a lot about today's webinar that is about helping you formulate the questions that you want to ask in your local community. Because it's different for different professions, and it's different nationwide, and it's different depending on the laws around your Fatality Review team. So it's important to understand that I can't tell you right now, this is the answer nationwide, you know, wrap it up in a bow, we're done. If I could, I'd probably have just sent you an email that told you the answer and not put you through a 90-minute webinar. So the question of whether confidentiality extends after death is going to depend on the ethical code and the legal statute that applies to the information. And the most important thing for any professionals who might be participating in Fatality Review or considering sharing information with Fatality Review is that they know what their rules are, and you honestly inform survivors in advance what those rules are. So here's an example of one that explicitly extends after death. Illinois has a domestic violence advocate confidentiality statute, and it has explicit instructions for how to handle releases information after the death of the survivor. So it's saying to you, there is legal confidentiality, and if the survivor dies, then that confidentiality stays in place, and here are the people who are allowed to sign releases of information. Alternatively, if you look at a state like Pennsylvania, I talked about Pennsylvania's statute earlier, and it's a very strong one, but it explicitly says that the protections terminate upon someone's death. Then we have what is probably the most common occurrence, which is a statute that does not say one way or the other. So as an example, the Vermont Domestic Violence Advocate Confidentiality Statute does not mention death at all. It does not provide a mechanism for consent after death, and it does not say that it terminates at death. So that's one where sort of the statute in question does not in fact have an answer to the question about whether it extends after death or terminates after death. So when you have a statute that doesn't tell you explicitly, and you have to figure out what to do, what I generally recommend that people do is you look at your state law in general. Does your state law generally protect legal confidentiality confidentiality after death. So often there might be no court cases whatsoever that look at domestic violence advocate privilege or sexual assault advocate privilege, but there are cases that look at doctor-patient privilege or attorney-client privilege. So you look at those in your state and say, is it sort of part of our state's policy to say that information which is confidential during life is confidential after death? And a lot of what I'm saying today is probably going to engage or involve either the attorneys who are on your fatality review teams or the attorneys that you're going to reach out to for help because they're allies of your fatality review teams to look at your state law and make some judgment calls. So the key questions when we're thinking about this after death question is really, what was the person who died, what was their reasonable expectation of privacy for this information? And that phrase, reasonable expectation of privacy, is a very key legal phrase. It gets used in all kinds of different cases all over the country. So what did somebody reasonably expect was going to be the privacy of their information? Did the program promise not to disclose to anyone? Because if you made an explicit promise not to disclose information to anyone, then you need to pay attention to that promise even after somebody's death. Again, as I said, does your state generally protect legal confidentiality after death? And then finally, what is the impact on your fatality review team and your state DV response if the deceased had an expectation of privacy and the fatality review team violates it? And I think violate is the right term. If we say this person thought their information would stay safe and we have a right to get access to it, so we're going to do it, that's when we get into the should question, which is that what impact does it have on your team and also on your whole coordinated community response to DV if we violate that survivor's expectation? What's the impact on future survivors and the impact on their safety and their willingness to access services? So that's confidentiality. Let's talk about privilege in a little bit of detail for a moment. I love this cartoon because it is pretty realistic actually how lawyers think, which is privilege means the court can't make you do something, but there's plenty of lawyers who have said, we'll be in good shape provided the judge doesn't go all legal on us. There's an old saying among lawyers that says, if you don't have the facts, argue the law, and if you don't have the law, argue the facts. So this is a case where privilege is the law, but I will be honest with you, as somebody who works on a national pro bono project defending advocate privilege, there are plenty of judges who decide they're going to make their own law in their own courtrooms, and we have to sort of duke it out with that. Privilege belongs to the client. What that means is that a client can prevent a professional from testifying about confidential communications. A client can prevent their attorney from going to court and testifying about confidential information, no matter how badly the attorney wants to do it. A client can prevent a therapist who has privilege from testifying in court, even if the therapist thinks it's a great idea. The privilege belongs to the client, and the court can't punish the client or the professional for not testifying. Now, some privilege is what we call common law, which means it's long accepted in the community. It appears in court decisions over usually hundreds of years, and sometimes it might be statutory, but there's an actual law that sets it out. When we look at sort of modern approaches to privilege and confidentiality, there are a fair number of statutes that offer both things at the same time, and they don't necessarily explicitly distinguish. But they will say, and Illinois is a good example of this, Illinois says no advocate in the state of doing domestic violence advocacy shall disclose a confidential communication or be examined as a witness in any legal proceeding. So they're sort of simultaneously saying you shall not disclose this information to anybody, and you shall not testify in court. And then there's an exception in there that says, unless the person whose information it is consents to having you do that. Because again, it belongs to the victim. And so the victim can say, you know what, I do want you to testify. I do want you to disclose that information. And that's important. I've been seeing that come up a little bit where some victims are saying, I want you to disclose this information, and some programs are saying, no, we don't want to, so we're not going to because it's confidential. Always remember that we're protecting survivor choices to share or choices not to share. But generally, anytime you have a statute that says that the information is privileged and no court can force you to share the information, that really means that no one else can force you either. Because what we're saying is the courts are the ultimate authority. They can force people to do things they normally would never do, and not even that ultimate authority of the court can force you to share the information. Statutes typically have some exceptions to privilege. So the exceptions to privilege might be, this is an example that comes out of a couple of different states. One state says if the court thinks substantial justice requires disclosure. So that means every court might be looking at the information and deciding whether they think it should be shared. Or if the court thinks that the confidential information includes proof that somebody has lied to the court or is lying to the court. So those are some exceptions to privilege that come up. Other statutes might specifically create an exception to privilege, and the most common one that we can usually think of is mandatory child abuse reporting. So, given that, what do we think about privilege after death, right? It's the same analysis as confidentiality after death. Does your statute address it? What is the general approach in your state? What was the reasonable expectation of the person to whom the information belonged? And is there a mechanism for a legal representative to sign a release or authorize disclosure? And then we want to think about what are the risks of an inadvertent waiver. And real quickly, what I mean by that is if you have a privilege for confidential communications, you only get to prevent someone from testifying about it if it's actually protected. So I was just reading a case this morning that talked about if somebody has the right to keep information secret, then they had better be keeping it secret, and they should treat that information like the crown jewels. And so if you don't keep the information secret yourself, then you can run the risk that a court might say, well, then if you're not going to keep it secret, we're not going to keep it secret, it's going to get shared. One example of that that's just a good pop culture example is when Martha Stewart was being tried for insider trading. She received an email from her lawyer giving her some legal advice, which is considered a confidential communication. And she forwarded that email to her daughter and said, what do you think? And once she did that, the court said she was not treating that information as if it was secret between her and her lawyer. She was sharing it with other people with whom she did not have legal confidentiality or legal privilege, so therefore it wasn't protected anymore. Okay, so I've been talking in generalities about the concepts of confidentiality and privilege and also privacy. I'm going to get into some more specifics, but again, I want to remind you that some of these specifics are federal law, and the federal law will apply to any group or organization generally that is accepting federal funding for this kind of work or under the statute. That's usually when these federal rules apply. And then some of it's about state law. And state law is going to be state specific. So I am giving you the questions that your team wants to go back and get answered when you do your confidentiality protocol practices and an annual confidentiality audit, which we're going to talk about that as a good practice. So I'm trying to give you direction on where to look for how information may be protected for your team. But I apologize in advance, it's going to be notably devoid of this is the rule in your town for your team, because that's sort of more than we can do, or than that I should try to do as a national technical assistance provider when you really want to focus on working with experts in your area. Okay, so the first example of federal law that protects information that may or may not be useful to fatality review is HIPAA. And lots of people have heard the term HIPAA, and they feel like they know what it means. What it actually means is actually fairly complicated, and there's a lot of rules and regulations, lots of twists and turns. It can be like being in a corn maze trying to make sense of HIPAA. But the bottom line of HIPAA is that it protects health information. A covered entity or a business associate, typically what that means is anybody who is using electronic communications to communicate about healthcare or to provide healthcare or to do billing for healthcare. Most people don't realize that that's the real key for having HIPAA cover you. And there are a couple of other categories, but primarily what it means is anybody who's using electronic communications in connection with providing healthcare, which is 99.5% of all providers right now. They are covered by HIPAA, and so they may not use or disclose protected health information, except for, you will notice that except for is a very long list. When I look at that list, I don't really see fatality review teams as being something that's squarely on that list. At the bottom of the list of exceptions, public policy exceptions, those are specifically defined. And researchers are also specifically defined in terms of what kind of information can be shared. So if your team is seeking protected health information of someone who is deceased, then you want to take a look at first figuring out, is the person you're trying to get the information from actually covered by HIPAA? I get questions an awful lot from programs that are definitely not covered by HIPAA asking me if how HIPAA applies to them. So first figure out if the covered entity or if the folks you're trying to get the information from are actually covered by HIPAA. And then if they are covered by HIPAA, is there something about your team in your area and the way that it's been constructed and defined that would allow it to access information without patient consent? That's the could you question. Of course, you're always asking yourself the should you question as well. The goal of the HIPAA privacy rule is to assure that individuals' health information is properly protected while allowing the flow of health information. HIPAA presumes that information is going to get shared to promote high-quality health care and to protect the public's health and well-being. HIPAA strikes a balance that permits important uses of information, and it's designed to be flexible and comprehensive. And that's just a site at the bottom of the page to a pretty useful website from the federal government on understanding HIPAA, and it has lots of subpages. In fact, another one gets referred to later in this webinar. So there is an element of HIPAA that assumes that information will be flowing and that there could be good reasons to share it. But I want to emphasize all of these exceptions to when HIPAA information does get shared without patient consent, they are defined either in the statute or in the regulations. So if you are seeking to get protected health information from a HIPAA-covered organization and you believe that you don't need anyone's consent to do it, then read those regulations, read those exceptions, and see if your team falls under it. HIPAA does explicitly protect health information after death. In fact, for 50 years after death. So the idea is that 50 years after someone has passed, their harm concerns, reputation concerns, living people concerns have reasonably gone away, and that information can then be available for research and public policy. But that's 50 years. Excuse me, teacher had to sneeze. So I know fatality review teams, sometimes you guys feel like you've waited forever to get started on your investigation, but I know you're not waiting 50 years. So that's not necessarily of assistance to you. However, after somebody has died, an hour after they have passed away, a personal representative can authorize disclosure of information. And a personal representative basically stands in the shoes of the individual. I've given you the HIPAA rule that defines a personal representative and another site to the hhs.gov website, which really goes through the details of HIPAA. And it's fairly readable. It's not John Grisham by a long shot, but it is possible to make sense of it, unlike some other federal publications. Okay. Now, thinking about mental health records, which mental health records are health information, they are protected health information, but they tend to get a higher level of protection because, much like we were talking about the stigma of being the victim of a gender-based crime, there's also a stigma to having mental health needs. So having a mental health diagnosis, seeking mental health treatment, these are things that people are stigmatized both in life and after death merely for having needed it, right? If I have a relative who died because of sort of a mental health concern, then I don't necessarily want to share that with people, even if I'm willing to share that the person passed away, because it stigmatizes someone after death. And there's this interesting point that I think reputation and stigma get even harder after somebody passes away because they're not around to speak themselves or change the story, right? They're stuck with whatever the story was at the time that they passed away. So mental health records are definitely protected by HIPAA, but they will often receive an even higher level of protection under state law. So that just the very fact that you visited a psychiatrist's office or that you had any diagnosis whatsoever is considered protected confidential information, because having that get out would stigmatize you. Okay, so that was HIPAA. I mean, HIPAA's privacy rule is essentially about confidentiality. It's about saying to health providers, you can't disclose information. You're under a law that requires you not disclose information. This is about privilege. Most states, not all of them actually, a co-presenter on another webinar recently mentioned that the state of Massachusetts doesn't have a medical privilege. Double check that if you're in the state of Massachusetts. I'm not trying to give legal advice, but that was something that was just shared with me by a colleague. But most states have privilege for doctors, medical providers, psychologists, and psychotherapists to not testify in court. So what that means is that no one can force that therapist to testify, and in fact the patient can prevent the therapist from testifying or prevent the doctor from testifying unless the patient gives written consent. And the U.S. Supreme Court has also given strong recognition for psychotherapist privilege. So doctor privilege and psychologist privilege has been around for a much longer time, but in a case called Jaffe versus Redmond, the U.S. Supreme Court said there's clearly very good reasons to be protecting the confidential communications between individuals and social workers or other clinicians who are not necessarily psychiatrists or psychologists, but are in fact providing therapy, counseling, and mental health services. So the U.S. Supreme Court has taken a pretty strong position saying that that information should be privileged, and therefore no one can force its disclosure unless the patient agrees. Another big category of information that's protected by federal law is alcohol and drug abuse patient records. Now you're going to be noticing a pattern here, right? Anything where the information that you disclose might be stigmatizing to you in the general public is an area where we are likely to protect the information under law. So alcohol and drug abuse patient records are protected from disclosure by Regulation 42 CFR Part 2. Now again, this applies to organizations that are accepting the funding that supports alcohol and drug abuse services. Most nonprofits that are doing the work are probably taking the money, but it's always a question to ask if you're ever asking, okay, can we get access to alcohol and drug abuse records? Well, the first question is, are they protected by federal law? And the first question of that is this organization covered by this federal law? But if someone is covered, what it says very clearly is that the patient must give written consent to disclose information, and it very clearly says that upon death, a personal representative or next of kin can give written consent. And then the exceptions to patient consent are a medical emergency, an audit or program evaluation. I'm not sure that a fatality review of sort of the whole system would come under that exception of an audit or program evaluation, but it's certainly something that you could have your local attorney advisors look at and see whether they think it does or not. Another exception is permitted research and vital statistics. All right, we are about 50 minutes into this sucker, and I'm feeling just a little bit lonely. So if everybody want to raise your hand if you're still here and you're not playing Call of Duty or Angry Birds on some other document. All right, yay, thank you. I'm a very social individual. I got lonely. Okay. Thank you very much for letting me know that you're here. Okay. So let's talk about federal confidentiality for domestic violence and sexual assault services. The laws that most likely protect that are the Violence Against Women Act and the Family Violence Prevention Services Act, VAWA and FIPSA. VAWA and FIPSA, the language of them is almost exactly the same. There's a little bit of differences, mostly because FIPSA was passed to model itself after VAWA, and then VAWA got updated shortly after. But they're definitely consistent in their intent and their meaning, which is that any grantee must protect privacy and safety of victims of violence. Remember, privacy is about the ability to make choices about who knows what. So grantees under VAWA and FIPSA are required to protect the privacy, the ability to make choices, and the safety of victims of violence. And they are prohibited from disclosing personally identifying information without the written, informed, reasonably time-limited consent from the individual whose information it is. And that includes that you can't even confirm that a person received services from grantees. And that makes an awful lot of sense, especially when you think about things like a domestic violence shelter. So if an abuser comes to the front desk of a domestic violence shelter and says, I want to know, is my wife here? And they say, you know, yes, she's here, but we can't tell you anything more than that. Sort of told them everything he needs to know, right? You painted a great big target on your shelter. Also, if somebody says, look, I don't want to know anything that happened to somebody, I just want to know, did they call your domestic violence hotline for help? You have disclosed that that person is a victim of domestic violence if you disclose that they called the hotline for help. So that means that under VAWA and FIPSA, you can't disclose any information that is shared with you by the victim of violence unless they give you a written consent. So then the question, because we're looking at fatality review, becomes what does VAWA or FIPSA do after somebody has passed away? Neither statute mentions the effect of death on this legal confidentiality. Both statutes mention a disclosure pursuant to statutory or court mandate. So both VAWA and FIPSA say, as an exception to our rule, you can disclose information if a statute requires you to do so, or if a valid court order requires you to do so. And if that happens, if a statute requires you to disclose information or a valid court order requires you to, then you must notify the victim and you must take measures to protect the safety of people affected. So why do I mention that when we're talking about what happens after death? Because I do think that VAWA and FIPSA contemplate that you might have a statute, such as a fatality review statute, that requires sharing of information. The other thing that VAWA and FIPSA both do is that they both allow releases to be signed by a legal representative of a minor or of an adult with a court-appointed guardian. And so why does that matter for after death? Because I think both VAWA and FIPSA recognize that someone else can have legal authority to step into the shoes of you to sign releases for you in the right circumstances. And so how would you figure out what the right circumstances might be? Again, look at your state law. So look at your general state approach to how does somebody step into someone's shoes when they're incapacitated or are deceased to give legal permission for things to happen. What is your state scheme for making that work? And then what is also your state privilege statute? So that's a really important thing to remember, is that you as a fatality review team might be trying to collect information from, say, a domestic violence shelter that is covered by VAWA or FIPSA. And you may come in and say, you know, VAWA or FIPSA doesn't say anything about after death, so we want you to share information with us. The VAWA or FIPSA rules are not the only question that people have to answer, because the second question that they have to answer is, what is your state-based protection? Do you have a state privilege that controls or protects this information? And then every program is going to follow the strongest law. So if the VAWA confidentiality protections or the FIPSA confidentiality protections are the strongest law that apply to that program, they're going to follow it. But if the state-based protection is stronger, they're going to follow that. And the reason for that is because we are enforcing people's expectations of privacy. So if somebody walks into a shelter and you say, hey, we get VAWA money and that says we can't disclose your information, And we also have a state law that says we can't disclose your information, and here's the sort of rules for that protection. People get to rely on those rules, so you're going to enforce the strongest law. And that's really part of what I was talking about before when you're trying to figure out what does your law, how does your law extend after death. Looking at every single state-based law that protects a certain kind of information is a key to doing that. So if you are unsure what the law is in your state for domestic violence advocacy, shelters, hotlines, sexual assault advocacy, you can get an answer to that question, or at least the beginnings of an answer, by going to the summary chart that Confidentiality Institute has created. So it was last updated January of 2014. It's amazing to me how fast a year goes by, but it was just updated in January, and it gives a summary of each state law as of that time that protects domestic and sexual violence advocate information and records. You can get to the chart by going to the tinyURL link that I have put on your slide right here. You can also get to it on the NDVFRI Safety Net tools site, and you can also get to it at the American Bar Association Commission on Domestic and Sexual Violence site. So that same chart, whenever it gets updated in all three places, is available there. That is to facilitate your research into what your current local law is. So that's the one thing I want to remind you of, is that law is a whole legislative session has gone by since the last time that was updated, and so it's possible that states that didn't have protection a year ago do have protection now, or that states have made changes to their protection. And this is an area where it does change, actually. I'm surprised every year when I go back how much there is that's new to report on. Okay, another area where you might, as a fatality review team, be considering reviewing records and they might be protected is educational records. Because of the most recent version of VAWA and concerns about the way that domestic and sexual violence interfere with the ability of young people, and most especially women, to get an education. The result of that has been that there is a real emphasis now on schools caring and paying attention when there is domestic and sexual violence in their school communities. This is especially a big deal on college campuses. So that means that schools might be getting more involved in investigation of and a systemic response to domestic violence. So if you're looking at fatality review and thinking about systems, you're going to want to know, how do schools respond? How is somebody able to stay in class or unable to stay in class because of the response that they got from their school? If you are seeking somebody's individual education records, they are typically protected by the Family Educational Rights and Privacy Act, called FERPA. And so you are going to have to pay attention to that. And again, FERPA only applies to schools that accept the funding, but almost all schools do. So it's extraordinarily likely that that is going to be an issue. So just think about that. Now, we're going to talk in a minute about what can you do if records are confidential and you can't get an individual person's records. How do you still get access to useful information from that institution or from that system? Attorneys, we talked earlier about the Swidler and Berlin versus United States case. Confidentiality between an attorney and a client is the oldest form of privilege. It goes back to the time of the Romans. They're always quoting that in various court cases. And the U.S. Supreme Court has explicitly recognized that that privilege survives death. And it's interesting, as I talk with folks who participate in fatality review, and you know, it's interesting to me to hear the ways in which the privilege of attorneys is so culturally accepted that we tend not to question it or even think about it. And some of that is because there's just too many lawyers on TV, and we're always being confronted with stories of lawyers keeping secrets. But it's very interesting to me that as a legal services attorney for 15 years, and we had clients, unfortunately, who were killed by their partners in my tenure. You know, we never experienced anybody saying, we would like you to tell us what your client shared with you so that we can improve systems. We would have said no, but I think because people assumed we would say no, and they assumed that our reasons were good, they would never ask us. So I bring that up in order to point out this distinction between the way that we might address things like domestic violence advocates or shelter workers who have often the exact same kind of information that attorneys have gotten in the exact same circumstances of privilege. And in fact, a lot of states, advocate privilege is stronger than attorney privilege. Usually attorneys have to at least admit that someone was their client, but often advocates are prohibited from admitting that somebody worked with them. So advocates actually legally have a stronger privilege in many states, and yet they have that experience of people coming to them and saying, we have good reasons, share with us everything that your client, the victim, told you, and then they're ending up in kind of a battle with people about it. So I point that out because I think it's interesting the way in which that we don't even talk about attorneys because we just assume what attorneys have is going to stay protected. Nobody's going to ask for it. And I was shocked when I shifted from being primarily a trial lawyer to being an attorney who helps domestic and sexual violence advocates. I was shocked to see the kinds of challenges that they were defending against that I just never ever would have been asked to defend against as an attorney. Religious officials is another very old area of protection, but also an area where folks might have information about survivors' experiences and struggles in trying to work with the system. That's usually also controlled both by the religious ethics, but also by state privilege law. And so it's worth looking at what are your laws and rules around protection for communications with religious officials, especially paying attention to the fact that those are changing. They don't get as much inherent respect as they used to, and there's more exceptions being created, primarily because of sort of the really frustrating experience we've had over the last decade of learning about some abuse by individuals, abuse of their position as a religious official. Okay, so at this point in time, we have 20 minutes left in the webinar, and you may well all be putting your hands to your heads and thinking, how are we ever going to get any information? You just went through this litany of laws that protect information, not to mention your incredibly insightful arguments about why it's important to protect information. You might be thinking, how do we get anything? How do we do our job? We know fatality review has value. How do we facilitate actually doing it if so much information is behind a wall? Here's some suggestions for how you can go about getting information while still respecting survivor choices and respecting confidentiality. The first is make use of publicly available information. There may well be quite a bit of publicly available information that you can get access to. For instance, you may not be able to ask an attorney what the client said, but you may be able to pull the paperwork that the attorney filed in the court case and read the statements from the client about what happened. There may be reports that were made to the police that are publicly available information. Always be paying attention to, is there anything that you can get that is publicly available that doesn't require you to violate someone else's confidentiality? Does your fatality review statute in your area specifically give you permission to see things? Does it specifically override the state-based privilege and say, this fatality review team is an exception to our state-based confidentiality and privilege, and it explicitly gives the fatality review team the power to look at, fill in the blank, whatever it says, to look at medical records, to look at advocate or shelter records. One of the things you want to look at as well is, does your statute then protect the information once the fatality review team has it? Does the statute say the fatality review team is allowed to get advocate confidential information? The fatality review team is prohibited from disclosing that information to anyone else. We call that a redisclosure protection. Does your statute have it? If your statute does not have it, then you want to sit back and ask yourself those could, should questions. We could get the information, and should we get the information? Same thing, even if your fatality review statute does have those protections. We could get the information. should we get it? Always think, if we get our hands on this, what potential harm could come? What potential good could come is something you want to look at as well, but definitely ask yourself what potential harm could come if we break through that confidentiality wall and get the information for ourselves. Ask yourself, can a legal representative consent to disclosure of the information? So it may be that we do not have the survivor there anymore to talk to and to ask for permission or to ask them to make a choice. But if your state law allows for it, or if the federal law at issue allows for it, can a legal representative step in and give consent to share the information? Because then you still have somebody who's exercising choice. And the idea behind that is that it's someone who knows the person that they are making decisions for, and can sort of apply what would that person want. Now, that's in an ideal world, but that is the hope under the law, is that somebody would say, well, my sister, I am my sister's next of kin, I am my sister's legal representative, and she has died. Would would she want to have this information out or not? Let me think about it, assess that, analyze it, and make that decision. It's still somebody with an insight into the desires of the survivor making a choice. And by way of example, I showed you earlier that the Illinois domestic violence confidentiality statute explicitly says after somebody has passed away, their legal representative is allowed to give permission to disclose information. And at this point in time in a live session, somebody would say, but what do we do if it's the abuser who wants to disclose information? And the answer to that is that every state that has a system for a legal representative allows somebody to say, not you, your interests are adverse to the person who has died. We're going to go to court and say it should be someone else, not you. Can you get someone's permission before death? So this is a question that's kind of bubbling up around the country. So a couple of states are experimenting with this. This is tricky, right? It is practically difficult to address with someone, their death. Now, there are definitely some victims who have high lethality risk. They know they have high lethality risk, and they are doing planning in the event of their own death. I remember very clearly during the O.J. Simpson trial in the 90s that Nicole Simpson had done, in the event of my death, planning. She had taken evidence and put it in the safety deposit box and given the key to someone and said, if I die, make sure this gets out. So we could certainly look at talking to victims who are doing their own in the event of my death planning about whether they would want to plan for sharing information with the fatality review team. The releases that they would sign would have to follow the same rules as the releases that they would be signing for information that they're going to share in an hour. They need to be informed. They need to be specific. Many statutes, including VAWA and FIPSA, require that releases be time limited. So that becomes a tricky question that I think is a discussion you want to have with your local council about what does a time-limited release look like in the instance of somebody with an unknown date of death, but who wants to control when information gets released. You want to think about that on a local level, particularly looking at the local statutes that apply to the information that's being protected. I'm a big fan of consulting living survivors. If there is the ability or the opportunity to talk to people who are survivors of near fatalities, then you have somebody who does get to exercise choice, who gets to have agency, who gets to participate in the narrative about their information, their story, their fatality review. I want to give a sort of electronic high five to Georgia that did a report in 2012 of a near fatality, and they actually invited the survivor to write her own narrative for their report of her own experience. That is honoring survivor choices and being survivor-centered. But if you're in a situation where you can't consult living survivors who are the actual, direct victim, then you can consult surviving family and friends who can contribute a wealth of information about services that are accessed and services that are denied. Consult experts in the field. So just because a confidentiality statute says that you cannot go to the domestic violence advocate who worked with the person to talk about the person's individual experience, you can go to a domestic violence advocate in your community and say, given the facts we know, a case that presented like this, what would be the typical response? And A, what would be the best practice response? And B, in your experience in the field, where do you see not best practices being implemented? Where do you see things falling down? Where do you see cracks? Where do you see holes? Where might someone like this have fallen between the cracks of what was supposed to happen? Go to those experts to talk about sort of their field. And sometimes it's they're freer to talk about it if they're saying, okay, well, I'm not ratting out one particular person in one particular situation, but here's what I see routinely happening to people who are in a situation like the one this survivor was in. Build a truly confidential fatality review process. So this is an extraordinarily important one, that if you are going to be in a situation where you can access confidential information and you have decided for your team that you should access confidential information, then the next question becomes, what do you do with it once you have it? Build a system that you can name, you can describe, that is actively protective of information. Let's talk about some of the details of what that looks like. First off, understand the protections in your statute, what they are and where they're weak. So one issue that comes up is, I talked earlier about how Martha Stewart, when she forwarded that email to her daughter, her lawyer advice was no longer confidential. Is the nature of your statutory setup that once information is shared with your fatality review, it might be subject to discovery, subpoena, review by a judge or a court disclosure? Or do you have a fatality review statute that says, nope, information that goes to fatality review stays with fatality review. Our fatality review is like Vegas. Information here stays here. There are statutes that say that. Does your jurisdiction have one? But the second follow-up question that I would ask is, has your state's court, highest court ideally, agreed about that protection? We're seeing lots of trouble nationwide where there are terrific statutes being passed to protect information, but then the issue comes up in a criminal case, and a criminal defendant says, it is my federal constitutional right to see this information, and local judges are agreeing with them, which is causing lots of people statewide to gasp and have panic attacks, because they're like, but we wrote a fantastic statute, and now we have an individual judge saying that the U.S. Constitution says differently. So ideally, you would like to have your state's highest court have said, nope, we've looked at this question and we disagree. We do not think that the either the state constitution or the U.S. Constitution requires disclosure of this information. We're going to enforce the statute as written. Or, and this is another possibility, does your statute allow judges to seek access to the fatality review team's information and then look at it for themselves and decide for themselves whether or not the information will get disclosed or not? You know, that's a hard one, because then it's dependent on every individual judge. And I can tell you as a trial lawyer, especially as a trial lawyer in Chicago, that every time I walk into a different judge's courtroom, it's a little bit like practicing in an entirely different state, because every judge has a different approach and a different reading of the law. And so saying to your team, to your local confidential professionals, or to survivors in your community, don't worry, we protect your information, but sometimes judges might ask permission to look at it, and then they'll make an individual determination whether it gets shared. It doesn't feel very safe. That doesn't feel very certain. And one of the things the U.S. Supreme Court has talked about, both in the Swidler and Berlin case and in the Jaffe versus Redmond case, is that the goal of privilege is to have it be certain, to have people know what's going to happen one way or the other. And I would say that any statute that says a judge gets to look at a file and make an individualized decision whether information gets served is a recipe for uncertainty. But let's say you've decided you can get information, you should get information, you do believe it's protected, then be sure you're actually protecting it. Does your whole team know what your protocol is for protecting information received? Does your whole team agree that they're not sharing information that they get back at their office with their colleagues? Does your whole team take very seriously the routine, appropriate destruction of information? Do you have a policy for when you destroy information, when you do or do not copy information, when you do or do not take detailed notes about information, and if you do take them, when do you destroy them? This is the part where it's not about should we get the information, but once we've got it, what do we do with it? And do you all follow the protocol? Do you expect each other to follow it? And I've talked to some folks who do fatality review who have said, I sort of informally take on the role of privacy monitor on the fatality review team, where at the end of a meeting, when everybody's scooping up the documents and putting them back in their briefcases, I raise my hand and say, wait a minute, we don't take those home with us. We, whatever your protocol is, we shred them, we leave them here, or we remember to keep them in a separate file that's locked and no one has access to. Whatever your protocol is, make sure everyone knows it and make sure everyone follows it. And make sure every time there's turnover on your team and somebody new joins it, that they know what it is and that they follow it too. And so this is a little bit more detail about routine destruction. We're getting in a space where I will go out and I will work with organizations and teams, and they will say, oh, we shred paper every 12 months. And I'll say, how do you destroy the information that you have scanned into your databases? And they look at me like a deer in headlights. Because the idea behind databases is that we can store infinite amounts of information for infinite amounts of times. Isn't that great news? And there's a lot of ways in which it is great news. But if you are dealing with sensitive information, confidential information, then you also need to have a policy and a procedure for destroying it electronically. And that's a discussion between your team and whatever electronic system you are or are not using to store information, and thinking about how is it getting destroyed. When you are writing your report, so say you've gotten access to confidential information, you got it appropriately, you're really careful about protecting it, but then you go to write your report, be very careful when you write your reports that you don't inadvertently identify people or disclose private information about them. It is possible, and I will tell you that I have done this with a fatality review report that was issued within the last 5 years in the United States. It is possible to take two different pieces of information about somebody and use it in Google to link it up. So if you write a report that says the victim was a 22-year-old with one child and the perpetrator was 60, and you also put in that report the victim had a mental health diagnosis and had been hospitalized for it, there's a pretty good chance that I can actually find out that victim's name, and I now know that that named person has a mental health diagnosis and was hospitalized for it, and I can then, knowing that person's name, I can then find their obituary, which means I then know the name of all of their surviving living close relatives. So really pay attention when you're writing out those reports. Are you giving just enough, no names, but just enough data points that somebody could use the incredibly powerful databases available to us to re-identify somebody? So anytime you can use something like victims, all the victims that we looked at were parents between the ages of 20 and 30. When you give those kinds of ranges, it makes it much more difficult for anybody to re-identify. So again, what we're doing is we are aligning the goals of fatality review and victim services goals with each other. Can we get information? If the way we get information is to force disclosure, should we force disclosure? How does that fit with increasing victim access to services? Because our ultimate goal is to prevent future deaths, it's to increase the safety of victims, to increase access to systems, and to create accountability for perpetrators. So I'm going to jump over this slide, which is just a reiteration of what our goals were for today, and look at questions. I'm a little bit later than I wanted to be in terms of answering questions, and I see that some people have sent them in. So one question I have is, does VAWA FIPSA prohibit me from reading exit surveys from survivors who leave a shelter? They work for a funding agency. The exit surveys have identifying information redacted, but they are open-ended questions. So that's a little bit more complicated than I can answer for you specifically, although if you wanted to email for technical assistance. I do, along with the National Network to End Domestic Violence, provide technical assistance on VAWA, FIPSA, confidentiality. But the big picture is that VAWA prohibits the disclosure of identifying information or individual information without a written consent from the survivor. And it does allow for the disclosure of aggregate, non-identifying information. So my first blush reaction is that reading individual exit surveys makes me nervous. I'm not going to say off the top of my head that VAWA would definitely prohibit it, because what the question asks is whether or not the information, the question says that identifying information has been redacted. The problem with redacting is redacting relies on the individual who is doing the redacting to make the correct guesses about what information will or will not be identified. And like the example that I just gave you for the fatality review that was clearly making every effort to protect the anonymity of this person, they inadvertently gave me just enough data points for me to re-identify the person and their living family members. So that's why redacting makes me nervous. And the language of VAWA does in fact say that you cannot disclose individual or identifying information, but you can disclose aggregate. If you want to look at that actual language, there's a summary of the law on tools.nnedv.org, which is the privacy and confidentiality toolkit and technology toolkit from NNEDV. So I'm going to, let's see. Okay, I think that is the big question that has come in, and I've invited you to connect with me by email, and that's my email right there on the page, alicia@confidentialityinstitute.org. And you can feel free to reach out. So Confidentiality Institute provides in partnership with the National Network to End Domestic Violence. We provide technical assistance on confidentiality and technology, most especially under VAWA and FIPSA. In partnership with the American Bar Association, we provide technical assistance on protecting information from subpoena. We help programs, we talked about setting up your confidentiality protocols. How do you actually work with information to ensure it's safe? Confidentiality Institute works with individual programs, we work with government, we work with interdisciplinary community teams on setting up their protocols so that they are actually protecting survivor choices, protecting privacy, enforcing confidentiality, and staying within the bounds of privilege. So thank you so much, everyone, for participating today. Thank you for all the work that you do to improve systems and outcomes for survivors. It makes an enormous amount of difference. And that's the end of our webinar. But if you do have more questions, look for the follow-up article that's going to get posted on the Fatality Review website. But also you can send me an email or go to the Confidentiality Institute website, or you can reach out to the National Domestic Violence Fatality Review Initiative.
Thank you so much, Megan. That was wonderful. I think everyone learned a lot of very useful information.
Definitely, I'm going to turn it back to you for the close us out.
So, just wanted to thank everybody for their participation today. Later on today, you will receive a link to an evaluation survey. We take the evaluations very seriously and use them as an opportunity to improve our future programming, so we hope you'll take a few minutes to fill that out. Also, please note that we are currently exploring how to house the webinar recordings. The event today was recorded. When we find a solution, since you registered for this event, you will receive an email with instructions on how to access our library. We also invite all of you to take an opportunity to explore our website at NDVFRI.org. And just to note that the National Domestic Violence Fatality Review Initiative is now housed at the Family Violence Institute at Northern Arizona University. We invite you all to just feel free to contact us as questions arise. We can either pass those on to our moderator today, or our presenter rather, Ms. Aiken from the Confidentiality Institute, or find you other resources depending on what the content of the question is. So thank you all again for your participation, and we hope to see you at our next event in January. Thank you.